Thank you, Madam Clerk. Call the next case, please, the final case of the day.
State of Tennessee versus Jared A. Smith.
All right, good afternoon, Mr. Scruggs.
Good afternoon, members of the court. Please the court. This is Mark. I'm Mark Scruggs of the Nashville Bar here on behalf of the defendant appellant, Jared Smith. I'd like to reserve maybe 4 minutes or so for rebuttal.
4 minutes?
4 minutes.
All right, you got it.
Judge, with your permission, I'd like to go to the second issue that I've raised, and that has to do with whether or not my client was denied his right to a jury trial in accordance with Article 1, Section 6 of the Tennessee Constitution, more specifically his right to a unanimous verdict. And this has to do basically focusing on the state's election of offenses. The election of offenses that the state presented to the court was about as general as they come. The victim in the case did in fact testify to specific incidents regarding specific sexual activity. The state chose not to identify that particular, those particular facts for whatever reason in their election of offenses. And what's interesting about the election of the offenses is that in count 1, where he was charged with child rape, the jury came back with a verdict of not guilty of that, but guilty of aggravated sexual battery. And the corresponding incest count, in count 8, I would submit, they found him not guilty. Because that's the only one where you had an allegation of anal penetration, and she said it just happened one time. So, you know, one time, that's pretty specific right there, okay? But the rest of them dealing with digital penetration or oral sex, or even the unlawful touching, the aggravated sexual batteries, she said that these things happen on multiple occasions over a 2 or 3 year period. I mean, the state could have very easily have gone in there and said, you know, we're talking about oral sex on this occasion, or digital penetration on that occasion, so forth. They could have done that, but they did not. So I, made my objection with regard to the election of offenses, the generality of it. Court overruled me and went ahead with an instruction, what is the traditional instruction, 42.25 of the pattern jury instructions for criminal cases of elections of offenses, what that basically says that the state has offered proof in its case in chief of more than one allegedly committed by the defendant, which the state alleges constitute an elements of the offense charged in this count. To ensure a unanimous verdict, the law requires the state to elect which alleged act testified to the state is relying upon for your consideration, deciding whether or not the defendant is guilty of the offense. That particular instruction requires the state to give a more specific election of offenses. They should have, the court should have instructed the jury with regard to 42.25A, which is in line with what the Tennessee Supreme Court directed in State versus Qualls, and that is in essence that the instruction should say that when the evidence the state has presented is general or generic, in other words, it's not identified with regard to a specific incident, then the jury must find him guilty of all of these incidents, okay? Everything, because she said, digital, oral, this happened 2 or 3 times, 4 or 5. She wasn't specific on any of those, okay, in terms of which one we're talking about. So, according to State versus Qualls, the scope of review in this particular type of case is that there is no presumption of correctness. It's de novo, and that basically this court looks at this issue as a matter of law for the first time. And so with regard to that particular part of our brief, I would submit that State versus Qualls is directly on point. It's almost word for word the same type of case as what we have here, all right? And that would be simply reversible error as a matter of law with regard to giving the improper jury instruction for this particular set of facts. The first...
Let me ask one question.
Yes, sir.
So in count 1, they found the defendant guilty of a lesser included offense.
Lesser included, that's correct.
And then, I'm not sure which count was the incest.
8, 9, and 10, and 11 were incest. And I would submit that they correspond. I'm guessing, of course, but because we don't really know, but I'm guessing that they would correspond to either the rape or the sexual battery, aggravated sexual battery. But they're not specific either, so we just don't know what they apply to. But what's interesting about it is count 1 and count 8 only dealt with anal penetration. And that's the only area where the victim testified it only happened one time. All the others, there were multiple times. So on the area that she was limited to, it just happened the one time. So I would submit that that's a great, that is evidence right there that the jury was confused with regard to what they're voting on here. And that denied my client his right to a unanimous verdict as guaranteed by the Article 1, Section 6 of the Tennessee Constitution. Now, the other issue that I raised is a little more touchy, okay? And that has to do with the judge not allowing me to cross-examine Detective Landis regarding his employment record. The fact that he had been in the process of being either fired or disciplined for being mishandling evidence in a case and misrepresenting to the court how he had handled that evidence in a case. And what had happened is that instead of going through that disciplinary process, he chose to resign rather than to fight those claims against him. These cases are incredibly close, especially when you have a swearing contest between the alleged victim and the defendant. In this particular case, I had to make a decision on how far I was going to go with regard to, I would call it the smoking gun. The smoking gun was the fact that this victim was interviewed twice. She was interviewed once where she described what had happened to her and how she knew about these things and so forth, okay? And then she was questioned again later by Detective Landis after Landis had interviewed Mr. Smith. And what had happened was, Mr. Smith's interview by Detective Landis is in the record. And what had happened is that Detective Landis conveyed to Mr. Smith that the victim had viewed a video of his wife, her mother, masturbating on Mr. Smith's cell phone. And the key was that this was in a part of his cell phone that required a special code to get to. You have a code to get into the cell phone, and then there was another code you had to use to get into this particular app. And Mr. Smith's reaction was, that's impossible, that couldn't have happened, okay? Because I've got a special code on that. And if you listen to it, you'll see how startled he is and amazed. He said that just could possibly not ever happen. And so when it came time to get into this issue at trial, since the judge had pretty much deprived me of any type of weapon I could use against Detective Landis, I chose not to go there. Now you could say that that's strategy. I would say it's something that I was forced to do because of the fact that the judge would not allow me to at least impugn Detective Landis's credibility. Because what happened was, in the second interview that the victim gave, she described how it was, just miraculously described how she was able to get into this app on Mr. Smith's phone. What she said was, yes, he opened up this other app to show me this. So I made the conscious decision not to go there with regard to cross-examination of Detective Landis or with regard to the cross-examination of the victim in this case, hoping that that would, I guess, get past the jury. Plus, on top of that, my client testified that she knew all of the passwords or codes to get into my phone, into the app, and so forth. The bottom line here is that, as I said before, these cases are incredibly, incredibly close. And when the court denies defense counsel the only weapon, the only possible weapon that he has, and that is impeaching or at least impugning the credibility of really and truly the state's second most important witness. The victim's the first, but the detective, I would say, would be the second. And how the victim came up with this explanation, that is devastating to our defense. And it was devastating in this case because, I think it's clear that the jury decided that because of this evidence, this claim by the victim that she saw this video on a special app that only Mr. Smith could get into, then that pretty much sealed the deal for us. So I would respectfully submit that I understand that the scope of review on this particular issue is abuse of discretion, but discretion in a situation where this particular piece of evidence is critical to the defense. And here what we have is we have a situation where Detective Landis was found to have been at the very least negligent, if not incompetent, in the way in which he handled evidence in a previous case and reported it to his superiors. So I would submit that I should have had the opportunity to get into that and also to ask him, well, you chose to resign rather than to fight this. Isn't that correct? And I think once the jury heard that, then they would know what that meant.
Did you make an offer of proof?
Well, this is where I guess we come in for PCR purposes, because I did not do that. What I did was I filed a motion to reopen the case with the court after I'd filed my motion for a new trial and so forth, and basically on the grounds of justice, asking the court to allow me to introduce that and to cross-examine him on that issue, and the court denied that. She basically said that's not the proper time for this. So, but I'll take full responsibility for doing that, and I've explained to you why I did that. And again, these cases are so close that, who knows, maybe it would have made the difference. But notwithstanding that particular issue, I would respectfully submit that the Qualls issue is definitive, that a new trial is required because there's no way that this court can make a determination as to whether or not this was a unanimous verdict. That concludes my argument. If you have any other questions, I'd be happy.
One more question. So if I guess I copied this from the state's brief in my little memo, and they've got a list of the number of offenses. Mm-hmm. So you're arguing that they start off by saying these occurred between March 3rd, 2012 and March 3rd, 2016. Are you basically saying on each of these they need to put a specific date to get around Qualls, rather than the type of activity they are saying that occurred?
For this particular type of indictment, what they should have done for each one of these is simply tied in the specific language, the specific testimony that the victim testified to in her testimony. I mean, I think that would have been easy for them to fix this had they done it right. Instead, they chose just this generic listing of these events without tying it to any of her testimony, when that could have easily been done. Instead, the only testimony from the victim was, with regard to one incident, was the anal penetration. The rest of them, the different types of oral sex and the digital sex, she said, occurred multiple times during these 2 or 3 year period. And yes, there was one particular one particular scenario that she talked about where this happened, all right? But she also said it continued to happen over and over and over. So we don't know what they were thinking of, okay, during that time period. And on top of that, does that reinforce her testimony that it happened multiple times over these years and so forth? Because that's, in these kind of cases, that kind of testimony is allowed in these child sex cases, where the alleged victim can testify that these things happen over and over and again, in spite of 404B and 404A. So I would respectfully submit that there was an easy way to fix this, but they chose not to fix it, and as a result of that, that is reversible error. Thank you.
Thank you, Mr. Scruggs. General?
Mr. Lundy, they're working you today, aren't they?
Yes, Your Honor, they are. Thank you very much for your patience with me. I promise you won't see me again today. So it's been a privilege to be here and to argue so very many cases before you this morning, this afternoon, all together. So As the court is aware, my name is Will Lundy, and I represent the state in this appeal. I'll start where my friend started, with the question of the election of offenses and whether the offenses that the state elected ensured unanimous verdicts. The Tennessee Supreme Court has held that if the evidence indicates various types of abuse, the prosecution may identify a particular type of abuse and elect that offense. This court has held that where the proof established that this type of incident occurred multiple times and only one offense was charged and one offense was elected, the prosecution's election of the type of sexual penetration or sexual offense was sufficiently specific to safeguard the defendant's right to a unanimous verdict on this offense. And that's exactly what the state did here. The state elected offenses based on the various kinds of sexual abuse that the victim testified to. I'd rather not get into all the various types, but in response to the defendant's argument about, maybe we should have put dates on these things, I think the issue is that the state only charged one charge per kind of offense, or per kind of sexual penetration, per kind of sexual touching, or whatever happened. And so this is very different than a situation where perhaps the victim testified to, multiple kinds of sexual assault and multiple kinds of and multiple charges were arrayed in for each one. So for example, if the state had charged, say, 2 or 3 charges per kind of sexual abuse alleged, then we'd be in different territory. And so I would just submit here that based on State v. Shelton and Tice, which I've quoted in my brief, that the state's election of offenses was proper here and ensured a unanimous verdict.
Okay, let's back up for a second. When you start talking about the election, and let's say it was, and just say, for instance, aggravated sexual battery or something like that,
Mm-hmm.
the indictment, the count of the indictment referred to one incident and not several incidents. Is that correct?
I believe that's correct, Your Honor.
Okay, so it wasn't a situation like like there were 2 or 3 incidents, and I've seen situations where there are like 2 or 3 incidents, and they would pick a particular place the person was living at the time, or it happened in a certain room to differentiate. There was only one allegation of oral sex, for instance, one allegation of digital penetration, things like that. Is that what you're saying?
I guess what what I'm saying is that, again, the Supreme Court has held that where the evidence indicates various types of abuse and the prosecution is allowed to identify a particular type and elect that offense, and that's what happened. I guess I don't read Shelton to require the state to, first of all, have a perfect election, as the courts talk about, but I don't read Shelton or Tice to require the state to say, where we have these multiple. If we had charged multiple charges per kind of offense, again, then we'd be in different territory, absolutely. Then I would say, yes, we'd need to identify this happened either on such and such a date, or where the victim lived, or something else to distinguish. But here, the distinguishing factor is the kind of sexual abuse that was alleged.
Okay.
And my argument is that satisfies the election requirement. Moving on then to the issue in Qualls, and my argument in response to the Qualls issue is somewhat similar, and I think it's a good thing to kind of distinguish Qualls, because Qualls isn't exactly on point. In Qualls, what you had is, I believe there were 2 victims in Qualls, and they both testified that the defendant sexually abused them, but they alleged the same kind of sexual abuse, and they said it happened over and over and over again. Maybe like once a week or every day or however much it was. It was a lot. And the way the state broke it down was, okay, this has been going on for a certain period of time, so we're going to make an allegation of, this, where the state says, okay, between this date range and this date range, that was how it was charged out. Maybe I believe it was like 1 charge per month or something along those lines. And it was in that context that the Supreme Court held that in order to define the defendant guilty, you must unanimously agree that the state has proven beyond a reasonable doubt the commission of all the acts described by the alleged victim. So that's the language from Qualls, and again is reflected in the rule, or reflected in the jury instruction, excuse me. The issue here is that what Qualls talks about is this modified jury instruction is required in cases involving only generic evidence. And Qualls is a classic example of that. There was only generic evidence. Again, it was one kind of sexual abuse, not multiple kinds, and it was committed over a long, long period of time repeatedly, and the victims couldn't remember any single incident at all. And here, the victim testified about this first incident of sexual abuse that involved the defendant bathing with her and having her wash him and all of these kinds of things. So that was not generic evidence. And as I read Qualls, I don't read Qualls to say that you have to give the jury instruction per charge. It's in cases involving only generic evidence. And because we had specific evidence here, the court was not permitted to give the modified jury instruction.
And when you say only, are you quoting from Qualls?
Yes, Your Honor, absolutely, quoting from Qualls. In Qualls, it says, quote, in cases involving only generic evidence. And so that's, again, if the Supreme Court were to hold that perhaps, per charge, that you would have to give this instruction for each individual charge, that would be different. But I have not seen a case that holds that. Again, what I have seen is Qualls, and it speaks of cases involving only generic evidence, which, again, we have specific evidence here. So finally, getting into the question about Detective Landis and his testimony, the issue here involves Tennessee Rule of Evidence 608, which prohibits attacking or supporting a witness's character for truthfulness or untruthfulness with extrinsic evidence of specific instances of conduct. But if an instance of conduct is probative of the witness's character for truthfulness, then a party may inquire into those instances and only on cross-examination and after the court holds a hearing to determine that the alleged conduct has probative value and that a reasonable factual basis exists for the inquiry. So that is, the question here is whether the evidence that defense counsel wanted to introduce with regard to Detective Landis was genuinely probative of his character for truthfulness or untruthfulness. And reading the record, he's absolutely right that Detective Landis was accused of mishandling evidence, and the court found that his handling of the evidence, and in fact the way he conducted his investigation, was negligent. But Detective Landis was never accused of lying, and the court never found anything that really impugned his character or for truthfulness or untruthfulness. It was simply really his competence as an investigator.
Mr. Scruggs mentioned that part of the reason that he resigned was because he provided false information or something like that to his superiors.
And as far as as I'm remembering the record, Your Honor, the instance that he was trying to introduce maybe he did give false information at one point, but the instance he was trying to introduce was that case where he was mishandling evidence, and that allegation just wasn't made there. So I guess I don't remember where that's coming from. And regardless, Detective Landis wasn't a particularly important witness. His testimony was extremely limited in this case. In fact, he didn't testify to any fact that was at issue. What Detective Landis did was he provided foundation so that the state could introduce his interview with the defendant, and that was it. Even if his testimony could be discredited based on what he actually testified to at trial, I don't see how there is any real prejudice here. I think any error would be harmless. Unless the court has any further questions for me, I will cede the remainder of my time. I would ask this court to affirm, and again, thank you for tolerating me so frequently today.
Thank you, General.
First one of these cases I tried was in 1989. And somehow or another, I got stuck with a whole bunch of them since then. One of the reasons you have an election of offenses is to give the defense some kind of notice as well as what are they defending against. And I always said that, I file my motion for bill of particulars so we can develop maybe an alibi. Maybe the defendant was in Europe when he or she says that he was doing this or that to her. Or maybe something about the surroundings, like a computer was there or a TV or a bed or something, didn't exist when this occurs, okay? You hardly ever get that in the answer to a bill of particulars. I'm telling you, you just don't get it. It's so rare. But you hope to get that kind of thing at trial. But then when you come to trial and the victim says, this happened, in the bedroom, this is how da-da-da-da, but then it also happened another 4 or 5 times over the next 4 or 5 years, what are you defending against then at that point in time? Okay, yeah, I was in Europe that day that you said that happened, but I was, I don't know where I was these other times because I don't know how to defend against it. It has to do with notice as well. How can you have a jury trial when you have all of this stuff coming in that you can't defend against? You really can't. And for the life of me, in reading Qualls, maybe I'm reading something different. The victims there did say that the defendant touched their rear end and vagina on multiple occasions and multiple months and so forth. And although you don't have, the full record there, it appears to me that they did identify specific incidents from what I can tell, but I guess you can read it for yourself and decide if that came up during the course of that, during the course of that case. And then lastly, with regard to Landis, what he did was, my recollection of it is that he misrepresented his actions during an investigation and also made those misrepresentations while under oath to the judge. And I think upon further investigation, they basically said he didn't intend to perjure himself or anything like that or to lie. Basically, he acted incompetently and negligently in what he did. So in terms of why he was being disciplined, I don't know if the record actually says it specifically, but I think that we should have had at least the opportunity to cross-examine him on that. So, thank you.
All right, thank you, Mr. Scruggs. That conclude our docket, Madam Clerk?
Yes, Your Honor.
All right, we appreciate the clerk's office and all your assistance with regard to these cases, and our state trooper back here for keeping us safe today. Very grateful to you and your other colleagues out there. And we'll be adjourned until, let's see, October, about the 10th or so, right around in there.
Yes.
All right, thank you.
All rise.